first share a few housekeeping matters so that we can all sit through today's webinar without any disturbance. The audio of each of our audience will be mute to ensure the maximum hearing of our speaker presentations. We also encourage participants to put forward any question you have in the chat box, so we will address this question at the later stage. Without further ado, allow me to introduce our speaker today, Mr. Ankit, who is the partner with Dispute Resolutions Department of Halim Hong and Quek. His focus area of practice is in construction law, and he has handled significant assignments involving energy project, engineering project, and infrastructure project for both local and foreign clients. Mr. Ankit's legal experience has enabled him to provide professional legal advice to his client in respect of building and construction project in Malaysia. Mr. Ankit has also represented a number of multinational and GLCs in Malaysia as lead counsel at all levels in Malaysian courts. He also often represents clients in adjudications and arbitrations proceedings. Today, he will be sharing with us on topic of contract management in construction project. Please join me to welcome our speaker, Mr. Ankit.
Thank you, Jacqueline, for your very kind introduction. So, ladies and gentlemen, without further ado, first allow me to share my screen on the topic for today. All right, ladies and gentlemen, this morning's session for discussion or for this webinar, I will be discussing on contract management in construction projects. Now, as you would all know, contract management is a very, very wide area per se. It involves many things, including most contracts or most construction contracts would actually include a proper agreement which is binding on the parties to the particular agreement. So it is usually between, for example, a developer and a main contractor, or between main contractor and its subcontractor, and so on and so forth. But essentially, construction contracts are necessary and relevant to regulate the particular stakeholders in any construction project, and therefore the understanding that one needs to possess in respect of the contract itself, the provisions in the contract, how they apply, and the workings of it is, in my view, of course, very important. So what I will be discussing here with all of you today is in respect of the PAM 2006 contract. So this is a very specific type of contract. As you would all know, there are many types of construction contracts. We have the PAM 2006 contract. Prior to that, we had the PAM 1998 contract. Now, very recently, we have had the PAM 2018 contract. There are also various other types of contracts, for example, like the JKR contract for government contracts. We have the AIAC standard form of contracts. And these are all basically options that parties have when deciding to enter into a construction contract. They would rather use an already existed and a tested method of a particular contract. Instead of coming up with your entire contract from scratch, you can use any of these contracts to regulate the particular contract itself. So this morning, I will be discussing the PAM 2006 contract, which, for your information, has got 8 articles in the contract and 38 clauses. Yep. Generally speaking, this is how the contract is. Of course, many a times the parties to a contract may modify a little bit certain aspects of the particular contract, but generally speaking, the PAM 2006 form of contract has got 8 articles and 38 clauses. Now, the 38 clauses include many things which basically regulate your entire contract itself, and it would include things like variations, practical completion, defects liability, damages for non-completion, extension of times, loss and expense. Those are just to name a few types of clauses that are included as part of the 38 clauses in the PAM 2006 contract. But this morning, I will be discussing with you all specifically on the 8 articles which are preliminary to the 38 clauses. So as I mentioned, 8 articles and 38 clauses. We will discuss the 8 articles itself. And these 8 articles essentially sets out the duties and obligations and the responsibilities of the players or the stakeholders in a particular construction contract. As you would all know, a construction contract may have various parties to it. Of course, you have the developer or the employer, you would have the contractor, you would have an architect, a quantity surveyor, and many other types of consultants, for example. And they all play a different role. And it is important to actually first find out or to first know the roles and obligations of each party. So without further ado, allow me to begin the session itself. Now, at the very beginning of a PAM 2006 form of contract, you would actually find something called the article of agreement, which is essentially what you see on your screen, wherein it actually states what the employer is desirous of, as you can see in the middle of your screen, essentially something which sets out the works or the particular works that are meant to be done under a particular contract. And if you see, it goes on to say that it has cost drawings and contract bills showing and describing the work to be done, to be prepared by his architect and consultant. And whereas the contractor has supplied the employer with a fully priced copy of the said contract bills, and whereas the said drawings numbered, I've left that blank because that is meant to be filled up for each contract, will state as follows. So it is to actually, the star in the middle is to actually set out the brief description of the works that are involved in the contract. So that is how your PAM 2006 contract starts up. The articles of agreement forming the beginning part of the document paves the way to the formal opening parts and recitals of the PAM 2006 form, which I will come to later. This part, of course, needs to be fully and properly completed. It is important that it comprises the date of the agreement, the names of the respective parties, the places of business or registered address, and a short description of the works to be completed with reference to the contract bills, drawings, and specifications. Now, it also further introduces the employer, the contractor, and the key personnel in the contract. It specifies the scope of the works, and most importantly, it states the consideration payable, and it contains the operational definitions of the important terms and expressions used in the contract. So it is a very important part of the contract because this actually sets out everything that is relevant for the purposes of the contract. If this part of it is not done properly, then you would have a problem or a potential problem in trying to exercise your rights in respect of other parts of the contract or other provisions in the contract. Now, the parties as identified in the recitals of the PAM 2006 form are principally the employer and the contractor. The term employer is used in the PAM 2006 form as the person who traditionally contracts with the main contractor as one of the 2 principal parties. Now, the term employer has been actually defined under Article 7Z of the PAM contract itself, 2006 contract, and it has been defined as follows. Employer means the party named in the articles of agreement and includes the employer's legal successors or personal representatives or any person to whom the rights and obligations of the employer have been transferred with the agreement of the contractor. Therefore, the employer, as used in the PAM 2006 form, is actually not a term of art. Instead, it is capable of actually embracing many forms, and it could include, as I've mentioned earlier, the client, the owner, the developer. It could even be a government or a statutory authority or anything else which falls under a category similar to this. The employer, of course, has a status and thus ought to be something we call a legal person, which means that whether it's incorporated as a company or a partnership or a joint venture, all of those would be examples of a joint venture, of a legal person. So the contractor, on the other hand, is the principal party to the main contract, and the contractor is employed to construct the project as designed for the price defined according to the terms of the contract. So again, this is important because it actually sets out the relevant relationship that is actually binding upon the two parties. One is the employer, one is the contractor, and the contractor is of course expected to deliver a particular product, which is the entire project being completed for a particular price that is defined according to the terms stated in the contract. And the word contractor itself has been defined as well in Article 7T of the PAM 2006 form, and it states that contractor means the party named in the Articles of Agreement and includes the contractor's legal successors or personal representatives or any person to whom the rights and obligations of the contractor have been transferred with the agreement of the employer. So as you can see, the definition is quite similar to the employer in the sense that it reaches out to even the legal successors of personal representatives and people who are going to take over the contractor, assuming there is a need to change a particular contract. Now, works, the word works has actually been defined in Article 7BF of the 2006 form, and it simply means to in the contract documents. It includes any changes made to these works in accordance with the contract. So again, this is where I have to come back to the articles of agreement. In the very beginning, you would actually set out the works that are meant to be described quite briefly, but it is important, I would say, at least to actually set it out in a very methodological manner, which actually stipulates the essence of the work that is required to be done by the contractor. Article 7AZ actually defines the term site, and it states that site means the land and other places on, in, under, over, or through. Okay, so it is quite a wide definition. It could be any part of the land which the works are to be executed and is provided by the employer for the purposes of the contract, including other land and places obtained by the contractor and accepted by the employer as forming part of the site. So again, this differs. In different contracts, the word site might only mean, for example, over the particular land. But in the PAM 2006 contract, the word site is actually quite all-encompassing. It also includes under and through the particular land, which means that even if works are being carried out under the particular piece of land in question, it would still be defined as site. It would still fall under the definition of site under the PAM 2006 forms. Now, the recitals in the Articles of Agreement also state that the employer has caused drawings and contract bills showing and describing the works to be done and to be prepared by his architect and consultant. The drawings referred to above must be in sufficient detail. Now, they must include, amongst others, architectural, civil and structural, mechanical and electrical, interior design, and landscape type of works. They show, or ought to show at least in graphic form, how the works are to be built, setting out the spaces, principal features, and the placement on site. So as you can see, it is quite detailed. All of this actually comes or falls into place after the agreement has been signed. And they would also go on to extend to include floor plans, elevations, and cross sections of various parts of the building, together with particulars of components and finish. Now, the term contract bills has been defined in Article 7R. As you can see, the beginning part of this slide, I have stated that the recitals also state that the employer has caused drawings and contract bills showing and describing the work. So we now need to ascertain what actually is contract bills to understand how the term actually functions insofar as the contract is concerned. So Article 7R is the relevant provision, and 7R actually states that the word contract bills comprises of the following documents. So it includes various documents, which is stated on your screen. The instructions to tenderers, the conditions of tendering, the form of tender, preliminaries, preambles and specifications, the bills of quantities, and any other documents specifically mentioned in any of the above documents. So it is not one document. When we say contract bills, it's really actually inclusive of various other type of things, which also includes the form of tender. Now, the contract bills are normally prepared by the quantity surveyor based on the information contained in the drawings. Now, the instructions to tenderers or the conditions of tendering and form of tender are basically, of course, self-explanatory. But what I think is quite important to realize is that the term bill of quantities is actually has not been defined anywhere in the 2006 PAM form. Therefore, we have got various scholars who would say that the term is actually something that is left to be implied by the parties to the agreement. One of our Malaysian authors in the area of construction law and arbitration and adjudication, Mr. Chow Kok Fong, explains that the bill of quantities normally consists of three principal parts. So it is a preliminary bill, the trades bill, and a schedule of provisional sums. And this has been obtained from his book titled The Law and Practice of Construction Contracts. So it's a very simple explanation of how the bill of quantities is formed and what it actually consists of. But the contract bills for the PAM 2006 form specifically actually differentiates the preliminaries, preambles, and specifications from the bill of quantity. Now, it would seem from the above definition that the bill of quantity is actually the trades bill. Yep. And in essence, it is a document of many pages subdivided into various trades, with each page containing numbered units of the works, a statement of the quantity of each unit, and a provision for the unit rate to be inserted by the contractor. Of course, the rate has to include the claimant's element of profit. That is the purpose of the entire document itself. Both parties are at the very outset already aware of each one's responsibility, the employer having to pay a particular sum of consideration in the form of money, and the claimant having to deliver a particular task or a completion of a task, which is essentially in the form of the building being completed. Now, it is normally prepared in accordance to a standard method of measurement, but the ultimate purpose of such an exercise in documenting all aspects of the required work is essentially to enable the contractor to price the works. The contract documentation then takes a form of an invitation to tender by the employer or his architect, engineer, or quantity surveyor to contractors describing substantially all aspects of the required work for the contractor to price. Then what usually happens is that the employer, who is normally acting through his architect or quantity surveyor, would send an invitation to tender based on the contract bills for the proposed works to two or more contractors, generally speaking. Such letters, it is important to note, are invitations to treat, and the employer does not bind himself to accept the lowest offer. Ultimately, you call out the tenders and you are essentially allowed to choose the particular contractor that you wish to appoint. It does not necessarily have to be the lowest tender. The contractor's offer to carry out the works is termed as a tender, and this is what is meant when the recitals add the words earlier that we mentioned, that the contractor has supplied the employer with a fully priced copy of the contract bills. So a contractor will generally be unable to claim the cost of preparing the tender from the employer. So put it very simply, you cannot prepare a tender and then claim for it. That's for contractors. Now, however, the contractor is entitled to remuneration where the employer makes use of the contractor's input into his tender or causes him to carry out works beyond what's reasonably necessary in the circumstances. So in short, there are certain examples or certain type of situations which would enable a contractor to actually claim for remuneration, especially when an employer makes use of the contractor's input in the tender. So be very careful, employers, when actually dealing with tender documents, because you can be sued for wrongful usage of the tender documents. Now, the recitals in the PAM 2006 form also recognize the standard procedure of examining the successful tenderer's priced bills. This means that when the articles of agreement is executed, the employer will have the price bills in his possession. Therefore, what actually I'm trying to say here is that the professional advisors who are involved in that particular project would be able to investigate, consider, and determine if the proposed contractor's tender is economically viable. They can then recommend to the employer or the developer, whichever it may be, whether or not to contract with the particular contractor itself. The drawings on which the contractor has tendered are called the contract drawings throughout the contract. And by clause 3.3, the contractor is actually entitled to receive one of the signed original copies of the contract documents, 2 copies of the contract drawings, and 2 copies of the unpriced contract bills. The contract documents must be signed by or on behalf of the employer and the contractor. This is essentially your starting point to any particular contract. Now, in practice, however, it is desirable that the architect, engineer, and the quantity surveyor should also sign the contract drawings as evidence that they are the drawings from which the quantities were taken off. So this is just good practice, which is highly recommended to ensure that there are no disputes or possible disputes that could arise later on, at least insofar as where the contract drawings are concerned. The contract is formed. This is when it's actually crystallizes. The contract is formed when the tender offer by the contractor is accepted by the employer. Before that, of course, the parties may normally have a course of negotiation, and relevant documents may be exchanged to show that the parties are finally ready to enter into the contract. It is at that point that a binding contract would come into existence, and this is then followed by bringing together all relevant documents into one contract documentation for execution by the parties. And that is why we have, ladies and gentlemen, specific forms such as the PAM 2006 contract form, which allows you to be like it's a sort of a one-stop contract document which covers all issues that are generally relevant in the construction industry. This is something that I have touched on earlier, but contract or contract documents in Article 7 has been defined as the following things. So it would also include the letter of award, ladies and gentlemen. So there are times, or there have been circumstances, cases that I've been involved in, where the terms in the letter of award and the terms in the agreement itself, the other documents, the articles and so on, the contract drawings, the contract bills are different, or they differ substantially in terms of the works or the type of scope of works that are involved and so on and so forth. So this is something that we should, as developers, try to avoid under all circumstances. There must be consistency in all documents, and we should leave no room for there to be discrepancies between documents such as the letter of award and the main agreement itself. Now, coming into the actual articles itself, as I've mentioned, there are 8 articles in total, and there are 38 clauses. Today's session will specifically deal only with the articles itself, which essentially, as I've mentioned, sets out the relevant parties involved, their roles, duties, and obligations. So Article 1 actually states or deals with the contractor's obligations under a PAM 2006 contract. Now, for the consideration hereinafter, what you see on your screen is essentially, sorry, my apologies. For the consideration hereinafter mentioned, the contractor will, upon and subject to the contract, carry out the works shown upon and described by or referred to in the contract. So this is what has been stated in Article 1. Very simply put, the simple, plain English language that is stated on your screen means that the contractor has to carry out a particular task, which is the works that are stated in the contract, and he will receive a consideration, which is also mentioned in the contract. Consideration in the form of remuneration, of course. Article 1 provides that the contractor's obligation is to carry out and complete the work spelled out on and subject to the contract documents for a consideration mentioned in Article 2. So, ladies and gentlemen, the sum that we always talk about, or the contract sum, which is the sum that is to be payable to the contractor, is always mentioned in Article 2 of the PAM 2006 form. The contractor, of course, does not, under a PAM 2006 contract, assume any design liability for the works, as his duty is only to carry out and complete the works in accordance with the contract documents. Unless, of course, those documents provide To the contrary, in respect of certain specialized work for which the contractor may be required to employ his own special expertise in design and execution. But generally speaking, he is not to assume any design liability. It is only in very limited and expressly stated situations would the contractor have such a duty. The article formally incorporates the contract documents into the contract. This has been stated earlier. And Article 2, which is the relevant part of the PAM form, which deals with the contract sum, states as per what you see on your screen. Yep, the employer will pay the contractor the sum of ringgit Malaysia, whatever the sum is, or such other sum as shall become payable hereunder at the times and in the manner specified in the contract. You see the word or such other sums as shall become payable is actually deliberately placed into an agreement, into the 2006 PAM agreement, because there may be times where the contract sum may have to be adjusted through variations or through certain changes in the job scope which parties may have agreed upon. So therefore, it has been worded in this particular way. And Article 2 of the PAM form requires the insertion of a sum of money, which becomes the contract sum. And as I mentioned, it can be adjusted or altered in accordance with the contract. The contract is one for a lump sum. That is a contract to complete the whole works for a lump sum, for a fixed lump sum. Now, provided that the works are substantially completed in compliance with the contract, the contractor will not be deprived of payment where the defects are minor. Apologies, just 1 second. Yes. Articles 1 and 2 of the PAM 2006 form contain a single promise by each party respectively. The contractor promises to execute the works in accordance to the terms of the contract, and the employer, on the other hand, promises to make a stated sum in payment. The nature of the contract is that of a lump sum contract. However, there are certain distinguishing features which cater for the special needs of the building industry, in that there are provisions for variations, periodic interim payments, extension of times, retention sums, and for adjustment of the contracts, etc. Just one additional factor, it's important to note here that Article 1, when we talk about contractors' obligations, must be read in conjunction with clause 1.1 of the PAM 2006 form. And essentially, it states that the wordings used there, it also includes, provides materials, goods and standards of workmanship of the quality and standard described in the contract documents by the architect in accordance with the provision of the contract. So there is an obligation for the works to be performed diligently, but essentially where the defects are minor, generally speaking, there will not be any claim against the particular contractor if the defects are only minor. You would still have to pay him the entire sum. Now, Article 3 deals with the architect, another very important player in the PAM 2006 form, but essentially the term architect in the contract, in the PAM 2006 contract, shall mean whoever the person is, of whatever his address is, and it goes on to state that, or in the event of such person ceasing to be the architect for the purposes of the contract, such other person as the employer shall appoint within 28 days therefrom. So the architect, as has been mentioned, states that no architect so appointed shall be entitled to disregard or overrule any certificate or opinion or decision or approval or instruction given by the preceding architect. So I will deal with what the role of the employer is, of the architect is. Now, the employer has a contractual relationship with the architect, engineers, quantity surveyors, and specialist consultants, usually by way of standard conditions of engagement. Articles 3, 4, 5, and 6 of the PAM 2006 form have the effect of specifying the architect and the other consultants involved in the contract and the scope of their duties. Now, it is clear from the provisions of the 2006 form that the employer has the duty to appoint the architect whose role is defined in relation to the employer. Now, it is a personal contract in the sense that the architect cannot arrange for the general performance of his duties by another person. The architect's task generally is as a designer to translate the employer's brief, yep, which is essentially means to coordinate and integrate the design inputs of the consultant's team into plans and drawings with such details and specifications as necessary to allow the building works to be carried out by others. So the architect's professional duties would also encompass the stages of schematic design, design development, contract documentation, finally, of course, construction and completion itself. The architect considers the employer's requirements and prepares schematic sketch designs to give form to the design brief. The architect then develops further the schematic design drawings to enable the other consultants such as structural engineers, mechanical and electrical engineers to do the detailed designing works. So as you can see, there's a relationship that forms between all of these participants in the particular agreement itself. The architect also is required to administer the building contract by providing the necessary information, instructions, and directions to enable the contractor to proceed with the works. He's also, of course, required to inspect the ongoing works. And finally, and most importantly, the architect will certify completion as under the building contract once the works are completed. The architect, as the what we call the principal submitting person, will also be required to issue the final sealing document, I call it, known as the Certificate of Completion and Compliance, which replaces the previous Certificate of Fitness for Occupation, yeah, which is what it was defined as under the PAM 1998 form. The employer is in breach if there is unreasonable delay. Sorry, my apologies, I have not dealt with this slide. Yeah, the architect may make use of the skill and labor of others in the performance of his duties, which I've mentioned. It has the relevant cases which are applicable over here. I've cited two British cases, but essentially in a PAM 2006 contract, the architect is actually allowed to engage the skills and labors of others in the performance of his duties. The employer would be in breach, yes, if there is unreasonable delay in appointing an architect as required by the contract. In such
Ankit, sorry, Mr. Ankit. We can't hear you. Sorry, everyone. We paused for a while because there's some technical problem.
Hello, can you all hear me?
Yeah, I can hear you now.
Okay.
I can hear you now.
All right. Sorry, ladies and gentlemen. I'm not sure. I didn't unmute it. So sorry, I didn't mute it. I'm not sure why it lost traction over there. So I'm not sure where I left off. But what I was saying is essentially that the architect can delegate his duties to other consultants who are involved in the project, but he would be responsible for acts and omissions that are performed by the architect itself, by the other persons whom he has delegated such duties to. Sorry, ladies and gentlemen, I'm not sure how come my screen left off. Okay, so the employer is in breach if there is unreasonable delay. I have mentioned that. I'm not sure if you all followed that, but in essence, the employer has to ensure that the architect is appointed within the stipulated period under the contract. So even if a particular architect has been appointed, he resigns, you as the employer are under duty to ensure that a new architect comes on board within 28 days to replace the former architect. Sorry. The architect, therefore, is said to often act in two capacities in respect of the same matter. For example, he may first be acting as the agent of the employer, and in that capacity, he has to decide whether works or materials are acceptable to the employer, and then he acts as the certifier to decide whether or not the works or materials comply with the contractual standards in the agreement, and whether payment should be made and the value of the relevant works or materials, at the value of the relevant works or materials. The employer also has to be independent, concurrent, and unlimited causes of action arising out of erroneous certification against both the architect and contractor. This is a quite trite position of the law, and you are actually allowed to take actions against the architect and the contractor in situations where there has been erroneous certification. Article 4 defines the term engineer, and I will not read out what it actually defines, but in essence, it is very similar to the provision defining the architect, which we dealt with earlier. Similarly, the employer is required to ensure that there is no unreasonable delay when appointing the engineer as required under the contract. And if in a situation an employer fails to appoint the contractor in the required 28-day period, the contractor will be entitled to claim later on for time and costs if the reappointment caused substantial delay and or loss and or expense, which are clauses which are provided under clauses 23 and 24. I won't be able to deal with this clause of loss and expense and delay and so on because they're very large clauses. Today is only for the first 8 articles. We will have future sessions which will deal with this, and then perhaps I could go into more in-depth explanation of how the loss and expense provision works in a PAM 2006 contract. Now, in the event the employer fails to nominate a succeeding engineer, as I mentioned, it will allow the contractor to terminate the contract after giving the requisite notice. Yes, so it's a very important position. If an engineer is not appointed within the particular 28-day period, the contractor can actually terminate the contract itself under clause 26. As you all would know, most of you, there is obviously a termination clause in the agreement. One is where the employer has the right to terminate, and the other is where the contractor has a right to terminate. So essentially, clause 26 is the particular provision which deals with termination of the contract by the contractor in certain specific situations. Again, I won't be able to deal in further detail of the particular provision, but suffice to say, this is what it states in brief. The contractor, of course, would be entitled to claim for loss and damages suffered arising from the termination, which includes loss of profits on his uncompleted portion of the works. This is very, very common and happens quite regularly, where the contractor sues as a result of the termination. He says that I have also incurred loss of profits for the uncompleted portion of the works. It's not necessarily allowed all the time. It is, of course, subject to the type of proof that the contractor is able to adduce during the arbitration hearing or during the court litigation hearing. Article 5 defines the person known as the quantity surveyor. And essentially, it states, if you see the second bullet point, the QS shall perform the duties expected of his profession, and the architect may from time to time delegate such duties and authority of the architect to the QS as the architect deems fit. So the QS and the architect, of course, work hand in hand. And the court, in a very old UK case, which is accepted in Malaysia, in Taylor and Hall, described that the traditional role of a QS is taking out in detail the measurements and quantities from plans prepared by an architect for the purpose of enabling builders to calculate the amounts for which they would execute the plans. Very simple and nice definition. And now at this time in day, well, while the quantity surveyors still carry out the taking off of quantities, his duties, the QS's duties essentially cover three stages. Yeah, firstly, the development and procurement prior to the building contract. Secondly, during the construction of the project. And thirdly, after its completion. The QS is required to advise the employer on the estimated cost of the project, the preparation of the tender documents, and the overseeing contract documentation works and the tendering process. However, it is of course most important, which is the main task of the QS itself, is to ensure that he still prepares the bill of quantities and makes his measurements and valuations skillfully. What I mean by skillfully here is by meaning we are fully dependent on the QS. He has an obligation to ensure that there's accuracy in the measurements and valuations that he's providing, failing which he could, of course, be sued for failure to diligently provide such accuracy. He will also be liable to the contractor for any fraudulent representations. For example, if the QS fraudulently, either for his own purpose or in collusion with the employer, takes out the quantity short, then in such a situation, he would be liable to the contractor. In the first case, he would be liable by himself alone. And in the second, where we talk about collusion with the employer, he would be liable jointly together with the employer. Again, this is a concept of law which has been accepted by our Malaysian courts, and it's been set out in the UK case of Priestley against Stone. QS can also be liable to the contractor in tort if he's negligent. This is of course a lot harder because we are going beyond the contract when we speak of negligence. Now, although the QS is responsible for the preparation of the contract bills, the architect, yes, has the overall responsibility for the bill. And during construction, the QS is required to support the architect in the discharge of his certification duties. As you will all know, this is one of the most important tasks, yes, certification. In fact, very often contractors sometimes don't get paid because the certification part has somehow jammed up at the architects and the QS's level, meaning everything has been submitted, but there is no certification. It is not being done timely or timeously. And therefore, the QS's job is to assist the architect as well in the discharge of his certification duties by assisting with the evaluation of the contractor's progress claims and recommending the amount to be certified to the architect. This again has been obtained from Chow Kok Fong's Law and Practice of Construction Contracts book. Now, upon completion of the project, the QS will value the contractor's final accounts and determine the loss and expense and damages which are due to the contractor as a result of permissible claims under the PAM 2006 form. And the architect and employer would, of course, be accordingly advised. This, as I've mentioned, is a very large area, loss and expense and damages, which we could perhaps discuss in the future webinars that we schedule to have with all of you. Article 6 deals with the specialist consultant, and a specialist consultant in the contract shall mean any person who performs the duties expected of his profession. And similar to most of the other players in the contract, the architect may from time to time delegate such duties and authorities of the architect to the specialist consultant as the architect deems fit. Now, unlike the 1998 form, the employer is not required under the 2006 form to nominate a replacement specialist consultant before appointing him. However, the contractor is also no longer entitled to object to the appointment of the replacement specialist consultant or arbitrate on it. Right now, the contractor can only object on the ground of lack of ethical or lack of technical expertise, or if there is reason to believe that the new specialist consultant has got some reason to say that the consultant would not carry out his duties properly. But essentially, as I mentioned, the contractor can no longer object unless in those very limited situations. Now, the removal of the right of objection means that the contractor has to continue to work with the replacement specialist consultant, even if he has reservations or has had unhappy previous dealings with the particular consultant. Similar to everything else, the employer has to ensure that there is no unreasonable delay in appointing the specialist consultants, failing which the contractor would be entitled to time and costs. And in such a case, the contractor would be entitled to claim for loss and damages arising from the termination, including loss of profits on his uncompleted portion of the works. It's exactly identical to the case of the contractor. Yep. These are new provisions which are not found in the PAM 1998 form, but we would see similar provisions in the 2018 form, which has recently come into place. Now, Article 7 is actually the article that defines all the relevant jargons that you would see under the PAM 2006 form. So I will not go into every single one of the definitions, save and except for those which are relevant, because this can be found from the PAM 2006 form directly. But in short, all the definitions are there on your screen. Each one of it has got a special definition, and I will only speak about some very relevant things in respect of Article 7. Yep. Now, first and foremost, the list of definitions in Article 7 is by no means exhaustive. Yep. Certain keywords and expressions, for example, the words regularly and diligently, liquidated damages, loss and or expense, best endeavor, are not defined or incorporated in Article 7. So whilst they appear in the body of the agreement, there's no actual proper definition for it in the contents of the body of the agreement itself. In such a situation, it is necessary to construe the meanings of such words from our relevant case law and authorities of the Malaysian courts. Now, one such example would be with regard to the phrase regularly and diligently, very commonly used. And the word regularly imports a requirement to attend to the work on a regular daily basis with sufficient labor, materials, and plant to have the physical capacity to progress the work substantially in accordance with the contractor's obligation. So whilst it has not been defined, this is what the plain and ordinary meaning of it is, which we have extracted from the relevant cases which have dealt with similar words. The word diligently refers to the need to apply that physical capacity industriously and efficiently towards that same end. Now, taken together, both these words mean that the obligation upon the contractor is essentially to proceed continuously, industriously, and efficiently with appropriate physical resources so as to progress the work steadily towards completion based on the contractual requirement of time, sequence, and quality of work. Just a very brief discussion on the term appendix. Yeah, it is normal for in construction contracts to have many set of documents attached to the appendices. Hence, it is important that the term appendix is actually defined, because the provision actually makes it clear that the word appendix in the contract refers only to the appendix to the conditions. Okay, so it's not a general appendix, it's only the appendix to the conditions. The word contract or contract documents, I won't labor too much on that. The word contract bills, again, I won't discuss that, but the term contractor in clause C has also been discussed. Now the term day, which is clause W, and the term month, which is clause AI, has been defined as well under the agreement. But these two definitions are important as they impact on the time-based rights and obligations of the contractor and employer specifically. So the PAM 98 defines both day and month as calendar day and calendar month. But now under PAM 2006, they just use the word day and month instead. Yep. And in the case of Migoti and Colville, the judge had taken occasion to say what you see on your screen. I'm of opinion that the term a calendar month is a legal and technical meaning. The meaning of the phrase is that in computing time by calendar months, the time must be reckoned by looking at the calendar and not by counting days. Yep. So if we have today is the 30th of May, 1 month or a calendar month from today would be 30th of June. So there's no need to get into the technical parts of counting 30 to 31 days. And if it's February, then it's 29 days and so on. The third bullet point, the term also now includes the weekly day of rest, but excludes gazetted holidays in the place where the work is undertaken. So remember, when we talk about the word day and month and all of that, it is where the work is undertaken. So if a project is being conducted in Johor, for example, then we would have only Sunday to Thursday as working days, because Friday and Saturday are holidays in Johor. The same would not apply for a project that is going on in Kuala Lumpur. Now, as I've mentioned, there's a difference between mandatory gazetted holidays and other normal ad hoc holidays. So this is what needs to be differentiated, which is what I mentioned in my third bullet point. And it is therefore important that the contractor must take care when programming the works and applying for extension of time. Or the relevant time schedule must always be calculated way in advance so that it is all above board. Other clauses that have been defined, I have cited just very brief descriptions of the particular clauses, but force majeure, which is a very popular clause recently due to the COVID-19 pandemic. This term is a new definition under PEM 2006, and it's not found in the previous predecessor form, which is the 1998 form. So if some of you are stuck with PEM 1998 contracts, then you're going to have a situation where the term force majeure is not even mentioned in the agreement. So you will not be able to rely on such things. And finally, which is the last clause under Article 7, meanings. These are the following terms that have been defined under meanings of the contract. Gender means words of one gender include the other gender, and words denoting natural persons include corporations and firms, and all such words have to be construed interchangeably in that manner. Insofar as headings and marginal notes are concerned, the headings and marginal notes are not to be taken into consideration in the interpretation or construction of the conditions of the contract. Reference to legislation. Yep, a reference to any act is deemed to include references to any subsequent amendments, consolidation, or replacement of the acts. So please, some parties or some clients actually will say that at that point the law was this, but that doesn't really matter, because it appears that the PEM 2006 form of contract has already encompassed into the agreement, has already considered for such a situation where there might be amendments to laws. Then the amended law would be the applicable one, even if at that point of time you entered into the contract that was not the law. Yeah, but there is an argument to this, because there may be times where there may be lawyers who will argue the issue of retrospectivity of a particular legislation, and whether or not something that is a new law that has been created today would impact an agreement which was entered into some many years ago. And finally, of course, the words importing the singular also include the plural, and vice versa where the context requires. So all this is actually mentioned in the PEM 2006 contract, and that is why I would actually recommend to most of you that when entering into construction contracts, do consider the different types of options you have, the different meanings that the different contracts actually take place. And today we have only discussed the 8 articles under the Articles of Association of the PEM 2006 agreement. We have discussed and we have basically deciphered the relevant roles and obligations of each party, and what are your responsibilities under a particular contract. Perhaps in the future sessions, which we will have in due course, we will deal with the more larger topics. So perhaps maybe for one of the sessions that we could have in the near future, we will deal specifically with the loss and expense clause, for instance, and go through the case law and all of that, which is relevant. Now, that would bring an end to my session for today, and I would like to thank all of you very, very much. And yes, if you all have any questions, please do state it in the chat box, and I will try my best to address all your queries. Thank you very much, ladies and gentlemen.
Thank you, Ankit. Thank you, Mr. Ankit, for the sharing. So now we'll proceed for if there's any Q&A. Can I know if anyone have any question? If you have any question, you have to unmute your speaker first. Okay, if there's no question, then this marks the end of our webinar. Thank you everyone for joining us. Thank you, Mr. Ankit.
Thank you, Jacqueline. Thank you.